Welcome back to Winning Isn't Easy. Sometimes court cases will read like mystery stories, sometimes they'll read like horror stories, and sometimes they'll read like fairy tales. I'm going to tell you the fairy tale story about the anatomy of a Reliance Standard claims denial and how a federal judge kept an airline pilot's any occupation benefit, hepatitis C, from crashing and burning. This is about the case of Tidal, Tiedel versus Reliance Standard Life. And this case lays out in great detail the anatomy of a Reliance Standard game plan for the denial of a claim and how one federal judge saw through the claim denial strategy. This case peels back the layers and shows you that you aren't on a level playing field with a disability carrier. The policyholder Tidal worked as a flight engineer for Kalitta Air. He had a disability insurance policy that was administered and funded by Reliance Standard. He suffered from hepatitis C, and because of a recurrence of hepatitis C, had weight loss, fatigue, memory lapses, joint pain, and fluctuating blood pressure. He also had side effects from his hepatitis C medication. He couldn't complete a flight simulation or pass a requalification exam. And as a result, he voluntarily gave up his flying privileges. Now, he was paid his own occupation benefits, but then when the definition changed, he was denied the payment of any further benefits because Reliance Standard said, look, you could do a sedentary occupation. So the Reliance Standard game plan was as follows. They denied his claim on the basis that the medical records did not support the conclusion he was unable to perform the material duties of any occupation. So how did Reliance Standard reach that great conclusion? Well, Reliance Standard concluded that he was capable of sedentary work. Now, that's defined as occasional exerting up to 10 pounds of force and working while seating with occasional standing and walking. Now, in my experience, a conclusion that a policyholder can perform sedentary work is the first step in the claims denial game. It's the kiss of death. So what did they do next? Well, Reliance Standard looked at the policy definition of any occupation, and it was defined as any occupation that's normally performed in the national economy for which the insured is reasonably suited based on their education, training, and experience. I call this the transferable skills game. So what they do is they look at the policyholder's education, training, and experience to determine if they have any skills that they've learned in their past occupation that would transfer to a new occupation that's sedentary in nature. That's the transferability of skills game done by an in-house vocational evaluator who is an expert, in quotes, in the world of work. What does the VE do next in this claims denial saga? Well, the VE noted his education, training, and experience and concluded that he had transferable skills, including the ability to convert technical ideas into working drawings, use complex math formulas, write clearly and with technical accuracy, use drafting tools or measuring instruments with coordination of eyes, hands, fingers, and maintain a high level of accuracy. So using their traditional game plan, the vocational specialist then determined whether there were other occupations that he could do based on his skills, education, and experience. And of course, guess what you think the VE said? Yes, he could work as an aircraft log clerk. Bingo! Reliance Standard denied his claim, and of course, he appealed. He submitted neuropsychological testing in the opinion of a qualified neuropsychologist that showed objective evidence of impaired speed of information processing, divided attention, and problems with short-term recall, and even executive functioning. Reliance Standard had never considered this in their denial. So on appeal, they devised a way to attack the neuropsychological opinion and testing. He also, by the way, submitted evidence from an ENT related to continued balance and falling issues, which, of course, Reliance Standard had never considered. So what did Reliance Standard do? They did the paper review game, and they had a paper review by the infamous insurance company peer review psychologist, Dr. Elena Mendelsohn. She's used extensively by disability carriers to deny claims. And of course, she dismissed the neuropsychological testing that documented the cognitive issues because, in her opinion, there had not been a comprehensive testing assessment. The neuropsychologist who had performed the testing hadn't utilized formal symptom validity measures in his evaluation. Obviously, gobbledygook. There was no evidence of a cognitive disturbance because the two IME providers who Reliance Standard had evaluated hadn't noted any cognitive disturbance during their examinations. Really? So what did the judge ultimately do? Fortunately, the court saw through this opinion and noted that neither the independent examiners, neither of them were ever asked to examine him for cognitive impairments. Duh. The judge said, the absence of evidence is not the absence of impairment. I like that quote, don't you? The judge then took on Mendelssohn's criticism of the testing and the opinions of the neuropsychologist. Now, she had talked to the neuropsychologist, and he said, look, I didn't need to use any formal validity measures. I thought he was credible. I believed him. The judge said, look, while insurers may ordinarily rely on a file review to deny a claim, when the file reviewer's conclusion relies on credibility determinations, reliance on that review by the disability carrier is inadequate. In other words, the court wouldn't give weight to Mendelssohn's rejection of the neuropsychologist's opinion based on her disagreement that he was believable when she hadn't even examined him. She'd only reviewed the medical records. And worse yet, she never explained why there was any reason to doubt his credibility. So while the judge noted that Mendelssohn had taken issue with the testing, she had also failed to sufficiently explain her concerns about the number and the quality of the testing. So the whole issue regarding validity of the testing, what testing was done and what wasn't done, was all based on his credibility. And since she had never met him, the judge said, I don't believe your credibility determinations. The court concluded that there was objective medical evidence that he suffered from cognitive impairments that affected his ability to work. And as a result, the judge found he couldn't even perform sedentary work. And the policyholder got his occupational benefits. So what are the lessons that we can learn from this case? Well, the first is that the absence of evidence is not the absence of impairment. And secondly, that the court isn't going to give weight to disability insurance carrier paper reviews when the reviewer's opinions rely on adverse credibility findings and the carrier's own file does not present to that evaluator or peer reviewer any reason to doubt the policyholder's credibility. There wasn't any surveillance. There wasn't any suggestion by his treating physicians that he wasn't credible. So this was a fairy tale result, but not all judges are going to look behind the uneven playing field created by disability carriers. When we come back, I'm going to talk to you about my next episode. In our next episode, I'm going to do some more myth busting. But I also want to let you know that in our fourth episode, coming up in 2 weeks, I'm going to take questions. I want you to think about what questions you have, and I'm going to answer them during that session. So I hope that you've enjoyed our podcast. That wraps it up for today. If you haven't subscribed to our show, please do so, and make sure that you are leaving questions on the link to the podcast. Thank you.